Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey, y'all, so it has been a while since I have done an update regarding TD Jakes and this defamation case against Duane Youngblood. The last we spoke, defendant Youngblood actually filed his motion to dismiss uh TD Jake's defamation claim, and this man is telling it like it is. He had affidavits that was attached that other people, even his brother Richard, gave an account of him and TD Jake supposedly having some type of altercation. I'm gonna call it an altercation or an incident. I don't know, but it freaked the heck out of Richard. Y'all, the affidavits was wild. Definitely. If you have not checked into those affidavits that I read, I suggest that you go do that before you hop into this video because it has to make sense. But I'm going to break this down into two parts. TD Jakes responded to Duane Youngblood's motion to dismiss, and then attorney Tyrone Blackburn, who's representing Duane Youngblood, filed a what would you want to call it? Like a memorandum, something to support Duane Youngblood's motion to dismiss. So I'm gonna do it in two parts. So this is going to be pretty much part one. This is going to be um, TD Jake's reply to Duane Youngblood's motion to dismiss, and then the second video is going to be a reply to this particular opposition by TD Jakes from attorney Tyrone Blackburn. So without further ado, let's tap right on into this. I don't want to hold y'all up. So it does reads plaintiff's opposition to defendant Youngblood's anti-SLAPP motion. I ain't gonna go through all that because we're gonna read them anyway. La da 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 da. Oh, they cited a lot of cases and statutes. Oof. All right, so let's see what TD Jakes, Bishop Jakes, done said. Baby, this is some juicy tea, baby, cause you be hearing stuff about what be going on in the church. Like I done heard it since I was little, but child, I never just would have thought it would have been so close to home. Like I never attended the Potter's house. My sister attended the Potter's house here in Dallas, but to just know that TD Jakes is not the first pastor to be accused of heinous allegations such as these. There's several pastors out here in Dallas that have been through the same thing. So in August of 2024, defendant Duane Youngblood left Pennsylvania State Prison after serving almost 10 years for exploiting his position as a clergyman to sexually abuse minors. Within 2 months of his release, Youngblood found himself on a YouTube podcast run by a longtime critic of plaintiff T.D. Jakes. There, he minimized his own conduct and cast blame onto T.D. Jakes or Bishop Jakes, claiming that he assaulted Youngblood in June of 1986 by cornering him, preventing him from leaving, and attempting to involuntarily kiss the teenaged Youngblood. He also claimed that Bishop Jakes called the next day and offered to support him for a life in exchange for sexual favors. That is all a lie. The tale reflects an ex-con's efforts to take advantage of Bishop Jakes, who had met Youngblood and his family through their involvement in the same Rush Belt church network, but of course never assaulted him, to deflect the blame for his own heinous conduct, to extort millions, and to launch a new chapter in his career along with his co-conspirators. Indeed, after his podcast appearances, Youngblood hired a publicist, launched a website, announced a new book, and created a life coaching and public speaking business. He also hired a lawyer, Tyrone Blackburn, to send a letter to Bishop Jakes demanding $6 million, or else he would file unspecified claims against him and his church. Instead, Bishop Jakes filed this lawsuit. Hey, y'all, don't this sound like another case that we've been talking about? But I'm gonna keep reading. Youngblood now attempts to avoid accountability yet again, this time by invoking Pennsylvania's anti SLAP law, necessary portions of which have not yet gone into effect, and misrepresenting its text and listing felons and family members to submit flawed affidavits and by lobbying more lies, all to distract from the issues. Those efforts failed as a matter of law and fact. Bishop Jakes believes in the power of forgiveness and also tries to turn the other cheek. No pun intended. But this is too much for anyone to bear. Bishop Jakes should be allowed to hold Youngblood and his co conspirators accountable for their lies and Youngblood's motion, and any attempts to attack the Jakes family and more false allegations should be rejected. Relative background. From extremely humble beginnings in West Virginia during the 1980s, Bishop T.D. Jakes builds a church in America's Rust Belt and beyond. Bishop T.D. Jakes is one of the most prominent and respected spiritual leaders in the United States today. He is the founder and senior pastor of the Potter's House Church in Dallas, Texas, which has a global reach and congregation exceeding 80,000 persons. He has authored 30 books, produced faith focused music and films, and has even won a Grammy. But that wasn't always so. Bishop Jakes grew up in a small town, West Virginia, and began preaching part time in 1980, founding a small church with just 10 parishioners while working at a chemical plant to support himself and his family. After the plant closed in 1982, Bishop Jakes spent the rest of the 1980s building a church while struggling to make ends meet, digging ditches at night. It was not until 1990s, after meeting prominent evangelical Carlton Pearson, oh really, and speaking at the 1993 AZUSA um, evangelical conference, I couldn't get that out, that Bishop Jakes first gained some recognition, which later grew into the Potter's House and national acclaim. Duane Youngblood gets caught sexually abusing multiple minors. He was counseling at his church and gets caught lying about it repeatedly. At the same time Bishop Jakes was building a community of the faithful, Youngblood was purporting to do the same. Unfortunately, Youngblood was abusing that portion of trust to exploit children. In January 2006, Youngblood was arrested and charged with abusing a 15-year-old boy he was counseling. After 2 years of denial, he pled guilty in March of 2008, receiving 1 year of detention and 7 years probation. But Youngblood did not stay out of trouble. In 2024, he was prosecuted again for additional X crimes against minors, which also violated his probation. During the sentencing for his probation violations, the presiding judge stated that Youngblood was a liar and a scammer who had misled and deceived the court. He had even manufactured evidence that about his travel plans while on probation and concealed his repeated arrests. During the hearing, Youngblood discussed his own past but made no mention of having been abused by Bishop Jakes, claiming that all incidents of abuse were before he was 18 years of age. Youngblood was sentenced to a maximum of and served over 9 years in prison. Duane Youngblood concocts the plan, with the help of others, to falsely accuse Bishop Jakes of misconduct. Beginning in October 2024, Youngblood and John Doe's 1 through 10 worked together to launch knowingly false and defamatory attacks on Bishop Jakes and accuse him of sexually assaulting a teenage Youngblood in a Pittsburgh area home. On October 28th and November 3rd, 2024, Youngblood appeared on the Larry Reed Live YouTube show, where he claimed that when he was a teenager, on or around June 1986, Bishop Jakes cornered him, prevented him from exiting the room, hugged him, and tried to kiss him without Youngblood's consent. Youngblood added to this false story by claiming that the next day, Bishop Jakes called him and told him that if Youngblood would be his guy in Pittsburgh, who he could have sex with whenever he visited, he would take care of Youngblood for the rest of his life. He then recounted two other fictional events to add credibility to his story. That one, that years later he confronted Bishop Jakes at a hotel while Miss Jakes was sleeping in the other room, and Bishop Jakes responded, "My stock was rising and I would have had X with anybody at the time." And two, the that another pastor tried to mediate a dispute between Bishop Jakes and Youngblood about this supposed assault. Those claims are completely fabricated. Bishop Jakes has never tried to corner, grab, or kiss any teenagers during his visits to Pittsburgh, and he certainly did not phone Youngblood to proposition him for X in exchange for financial support. He never apologized for doing so because it didn't happen, as Youngblood very well knows. And the stories make no sense because, as explained above, in 1986, Bishop Jakes was a small town preacher who could barely support his own family, let alone another person in another city. Youngblood's motivation for making up these stories became clear shortly after. On November 9th, just 6 days after the second Larry Reid live interview, Youngblood purchased the rights to DuaneYoungblood.com and created a launching soon placeholder webpage. On November 15th, Youngblood's lawyer sent Bishop Jakes a letter demanding $6 million and a response by November 23rd, or else they would file a frivolous lawsuit designed to embarrass him. He even claimed that Youngblood may have been 17 years old during the fictional incident to make it even more salacious. Instead of cultivating, Bishop Jakes filed the suit on November 25th. After receiving an extension to respond to the complaint, claiming he needed more time to find counsel despite having long ago retained Blackburn, that's what I questioned too, y'all. But before filing his response, Youngblood launched his business on January 12th, 2025. According to this website, he offers workshops and one on one coaching on how to move from past trauma. He even hired a publicist to help. The website features the Larry Reid live interviews and a countdown for the release of his new book. I overcame it to the live my best life, which promises to go into sexual abuse and betrayal by prominent spiritual leaders, including Bishop Jakes, set to be released through Amazon on March 3rd, 2025. And 2 days after filing the instant motion, Youngblood's attorney Blackburn appeared on the Larry Reid Live to boast about his motion and attack Bishop Jakes, but not before he provided Reid with a draft version of Youngblood's anti-slap motion, which Reid broadcast. Youngblood falsely attacks Bishop Jakes' son with a made for litigation claim. On November 3rd, 2024, before Youngblood's second appearance on Larry Reid Live, Bishop Jakes' son Jermaine sent a message to Youngblood after seeing an ad on social media for the Larry Reid Live appearance. Jermaine sent the message to warn Youngblood about getting involved with Larry Reid, who Jermaine knew to be a destructive person. Tellingly, Youngblood responded to Jermaine's message that the concern was noted, which Youngblood omitted from his filing with this court. 2 days after Bishop Jakes filed this suit, Youngblood then filed a complaint with the Pitcairn, PA Police Department against Jermaine. Youngblood admitted to the intake officer that his attorney wanted the complaint on file. So, one, there was more to those messages that we seen, and two, he really didn't want to file. Tyrone Blackburn insisted him to file. Noted. Youngblood enlists convicted felons and family members to submit bogus affidavits. So all those affidavits, baby, that we read the last time, and that man said he climbed into bed with him. Lord, whew, child, the Lord ain't pleased. To try and bolster his own lack of credibility, Youngblood enlisted 7 people with no firsthand knowledge of the events at issue, who claimed that Youngblood told them his story at various times since 1990. But each of their claims are flawed, including glaring inaccuracies, contradictions, and omissions. Ooh, this about to be juicy. So Joshua Muniz omitted from his affidavit that he was convicted of a child ex abuse crimes, is a registered ex offender, and that Youngblood was in prison when he allegedly told Muniz about Bishop Jakes over breakfast. Shut the front door. Affiant London Claiborne is also a convicted felon who served 41 months for heroin distribution but omitted the fact from his affidavit. Affiant LaShawn Youngblood's story about her husband telling her about Bishop Jakes a few years before the spring of 2015 is directly contradicted by her and her husband's prior statement to the court in 2014 and 2015. Affiant Jeffrey Gray did not work for Merrill Lynch in 1992 when he claims Youngblood told him about Bishop Jakes. Affiant Daniel Spalding stories about Youngblood telling him about Bishop Jakes would have taken place right after Youngblood's arrest and first charges for sexually assaulting a minor he was counseling. Here's the biggest one. Richard Youngblood is the one that he said TD Jakes climbed into bed with him. So let's see what they say. Affiant Richard Youngblood's entire story, both his own tale and his brother's sharing his, are belied by Richard's own history of vindictiveness against Bishop Jakes, including the facts that Richard began plotting against Bishop Jakes in 2008 when Bishop did not speak up for Duane at his first criminal sentencing hearing, and that within the last 10 years, Richard has begged for a job and assistance, which Bishop Jakes rejected. And last but not least, with regard to Youngblood's psychological impact report, it conspicuously omits whether and when the therapist first met Youngblood or when he recounted his story, including whether they were after the filing of this lawsuit, and simply accepts as true Youngblood's false accusations about Bishop Jakes. The affiant's testimony must be tested through cross examination. These issues were all uncovered without the benefit of any discovery and are likely just a tip of the iceberg. So, what they're saying is they haven't even entered the discovery phase yet. Written interrogatories, requests for production of documents, they haven't even got to depositions yet. And they have found out all of this information already. People are felons, people are registered ex offenders. Like, what? This person didn't even work at Merrill Lynch in 1992. What? All right, so let's look at Bishop T.D. Jakes' argument. So, Youngblood's motion is both procedurally and substantively flawed because the anti SLAPP statute does not apply, and even if it did, Bishop Jakes readily satisfies its standards. Part A, statutory issues are fatal to defendant's anti SLAPP motion. Youngblood's motion does not invoke Federal Rule 12 or discuss the relevant considerations under its standards because he knows he cannot meet it. Instead, he elected to file an anti SLAPP motion relying on matters outside of the pleadings to contradict the complaint's well pled factual allegations. The motion relies on Pennsylvania's novel anti SLAPP law, parts of which went into effect in July 2024. The law contains a substantive section which requires the plaintiff to have a valid claim under various procedural standards, providing an immunity where one, the plaintiff fails to one, establish a prima facie case as to each essential element, or two, state a cause of action, or where two, there's a no general issue as to any material fact, and the defendant is entitled to the judgment as a matter of law. And the procedural section creates a mechanism for enforcing those rights through the anti SLAPP motion, section 8340.16. Two issues are fatal to the defendant's motion. One, the procedural section has not yet gone into effect. And two, state anti SLAPP statutes, like this one, are fundamentally state procedural rules that do not apply in federal court. Because Youngblood cannot file a Pennsylvania anti SLAPP motion and has not provided any other basis for dismissal, it must be denied. This goes back to Youngblood not knowing what the F he's doing. And I stated that in the Little Rod case. And I pray that the plaintiff that he is representing in the case against DJ, in the essay case against DJ Academics, he know what he's doing. Because you're talking about an attorney messing up cases. Tyrone Blackburn is that attorney. There are no anti-SLAPP motions in Pennsylvania yet. So that's part one. While parts of the new Pennsylvania anti-SLAPP statute went into effect in July 2024, the provision creating the anti-SLAPP motion and related procedures, section 8340.16, is not yet in effect. That's crazy. They're trying to apply something that is not even in effect yet. And it states, so until the Pennsylvania Supreme Court acts to create anti-SLAPP motions, they do not exist in Pennsylvania. And then even if they did, it doesn't even apply to the federal court. It doesn't even apply to the only state courts. Five federal circuit courts have held that the anti-SLAPP statute conflict with valid federal rules of civil procedure and therefore cannot be applied in the federal forum. So that's why it cannot apply on the federal level. Boy, boy, boy. In Pennsylvania, Section 8340.15, one's burdens of persuasion conflicts with the federal rules. In a federal court, it is defendants, not plaintiffs, who bear the burden of demonstrating that the Rule 12b6 motion to dismiss should be granted. So they're applying something that I don't understand why. I'm about to say Busby. Why Tyrone Blackburn did not know that. I need to go check to see how many cases has he done in federal court, because this is the same dude that was filing in one jurisdiction, but that he wasn't even supposed to do that. It was the wrong jurisdiction. And then he's filing in the state court and it's supposed to be in the federal court. Regardless, the lawsuit is not a slap. It is a meritless claim. Youngblood offers little coherent guidance on what he believes the required anti-SLAPP showing to be, except to falsely claim that the law employs a burden shifting framework and that once a defendant demonstrates that the action arises from protected expression, the burden shifts to the plaintiff to establish a probability of prevailing on the merits of their claims. But Youngblood misrepresents the standard set by the Pennsylvania legislator. Neither the cited provision nor any other part of the law impose that framework or require that showing. Even assuming that the statute applies and that his statements qualify as protected public expression, Bishop Jake's lawsuit meets its requirements by a long shot. No matter the standard, Bishop Jake's defamation per se claim stands. The Pennsylvania anti-SLAPP statute does not bar viable defamation claims like those arising from Youngblood's lies about Bishop Jakes. A libel is a malicious written or printed publication which tends to blacken a person's reputation or to expose him to public hatred, contempt or ridicule or injure him in his business or professional. Youngblood incorrectly claims that Bishop Jakes has failed to show falsehood, actual malice, and damages. None of the arguments are availing. Youngblood's claims about Bishop Jakes are false. Between October 28th and November 3rd, on those podcasts, Youngblood leveled the following false accusations against Bishop Jakes: that when Youngblood was in his late teens, Bishop Jakes cornered him, wrapped his arms around him, and tried to kiss him in a way that Youngblood found threatening and predatory, in other words, sexual assault. Afterwards, Jakes called him and said, "There's three things I need you to do. The first one is when I come to Pittsburgh, you're going to be the only person I sleep with. The second one is you can't sleep with anybody else because I don't want you giving my wife anything. And thirdly, I will take care of you for the rest of your life." He also stated on those podcasts and that there is so much more to me and Bishop Jakes and my family and Bishop Jakes and the absolute destructive actual damage. Youngblood's motion does not dispute the gist of his lies, that Bishop Jakes groomed, sexually abused, sexually assaulted, and engaged in predatory conduct of an sexual nature. None of this is true. It is complete fabrication. While Bishop Jakes occasionally traveled from his home in West Virginia to Pittsburgh to preach in the mid 80s, none of the salient events Youngblood describes occurred. Bishop Jakes never tried to corner, grab, kiss any teenagers during this trip, and he certainly did not call to proposition him for X in exchange for financial support. Bishop Jakes' denials satisfy his burden on falsehoods, even under the highest possible standard. And while Youngblood offers countervailing declarations, courts don't weigh credibility at the anti SLAPP phase, even under the most robust anti SLAPP laws. But if the court did weigh credibility, it should not credit anything Youngblood, a known liar, says. As one judge found during a 2015 probation violation hearing, Youngblood has lied and he has scammed and he has conned me from the day he stood in front of me. 7 years earlier, I have been misled. I have been deceived. I have been actually lied to by Youngblood. At the same hearing, Youngblood testified about his own history of abuse, but he told the court that he'd been assaulted at the age of 12 in 1979 in a penthouse after he won a singing competition. The incident bears no resemblance to any of the 2024 allegations he made on Larry Reed Live, and he stated that all incidents of abuse were before he was the age of 18 years of age. Despite having any Despite having an incentive to discuss all abuse he suffered to explain his own ex crimes and mitigate his sentence, he did not mention Bishop Jakes or anything resembling his new accusations. That is proof that his new accusations are lies and that he and his affiant's statements lack credibility, in addition to other reasons to doubt them. Further undermining Youngblood's claims is the reality that in the mid 1980s, Bishop Jakes wasn't a wealthy, globe-trotting preacher who could support Youngblood for life in exchange for sexual favors whenever he came to Pittsburgh, nor was his stock rising such that he would have X with anybody at the time. Rather, throughout the 1980s, Jakes lived in crushing poverty, having only become a full-time preacher in 1992 after losing his job at a chemical plant which closed. He only began to experience modest success at the absolute earliest in 1992. Far from being able to support Youngblood, in 1986 Bishop Jakes was a humble Rust Belt preacher who could barely afford to maintain a storefront church in rural West Virginia. The tales are ex post facto inventions full of anachronisms that reflect Bishop Jake's post 1993 success rather than the reality of the mid 1980s. Youngblood's claims were made with actual malice. The circumstances of the case vividly demonstrate that Youngblood knew he was lying about Bishop T.D. Jakes, but did so for money, fame, and even revenge. The actual malice inquiry, a creature of the First Amendment, asks whether the defendant published a false statement with knowledge that it was false or with reckless disregard for the truth. Although the defendant's state of mind is the focus, plaintiff will rarely be successful in proving awareness of falsehoods from the mouth of the defendant himself because defamation defendants are prone to assert their good faith belief in truth of their publications. Therefore, courts are guided by circumstantial evidence. By examining the publisher's actions, we try to understand their motives. In this inquiry, all the relative circumstances surrounding the transaction may be shown. Let me see. And while no single piece of the evidence will support a verdict that does not meet that together, all the evidence may not be clear and convincing. Pieces to a jigsaw puzzle sometimes appear nothing more than scattered fragments, but when placed together in proper fashion, they create a clear picture. Here, the evidence of malice paints a compelling picture. In August of 2024, Youngblood completed a 9-year prison sentence and needed to build a new life. To that end, Youngblood initiated a plan to transform himself from a ex-offender into an inspiration, even enlisting a publicist to help. By October, he joined forces with wannabe spiritual leader Larry Reed, who regularly books guests to attack Bishop Jakes on Larry Reed Live. Working with Reed, Youngblood told his new story that Bishop Jakes played a part in his abuse. The story was a gold mine for Youngblood, allowing him to appear on Reed's show, garnering attention for his business and recasting him as a victim rather than the minors he abused during the counseling sessions. And just a few weeks later, he dispatched a lawyer to demand $6 million from Bishop Jakes, or else he would sue for unspecified tort claims arising from the tale. Youngblood's fabrications also furthered his brother Richard's vendetta against Bishop Jakes, which began in 2008, shortly after Duane Youngblood pled guilty to child M word. According to the acquaintance of Richards, Richard mentioned that Jakes has known his family so long that a man of his caliber could have easily spoken up in his defense for Duane and maybe aided for his case. He wanted Bishop to know how it felt to be falsely accused of the same thing his brother was. Richard was determined to get retribution for his family and the pain of such allegations has caused him. After Duane's guilty plea, Richard made his accusations. To effectuate those goals, Youngblood fabricated a story about Bishop Jakes that sounded compellingly but was false. Because Youngblood claims to have personally witnessed conduct that never occurred, the lies about Jakes were necessarily made with actual malice. Let's see. In reply, Youngblood may suggest that he said type dispute in sufficient evidence to show actual malice, but he would be wrong. This case is not a defamation case against a publisher or a journalist investigating events about third parties. Rather, the complaint here alleges that defendant knew the post was false and when she published it because the events recounted never took place, which suffices to show malice. Accordingly, Given Youngblood's substantial motive to make up stories about Bishop Jakes and his total fabrication of the events described, plaintiff can readily shoulder his burden. Bishop Jakes has made the required damages showing in his defamation per se case. Because Bishop Jakes has made a showing of actual malice and brought a claim for defamation per se, no additional showings of damages is required. As in other states, Pennsylvania considers an accusation to be defamatory per se when it is obviously defamatory, such as when it imputes one, a criminal offense, two, loathsome disease, three, business misconduct, four, serious sexual misconduct. This includes accusations of sexual abuse, like those leveled at Bishop Jakes. Such accusations obviously harm the accused, so damages are presumed, obviating the need to prove them as an element to the claim. In the case Youngblood cites, does not abrogate this doctrine. Rather, under Joseph, when private figures plaintiffs establish liability based on negligence, recovery is restricted to compensation for actual injury, thus eliminating the specters of presumed and punitive damages in this regard. Mm, they got you there, buddy. As Joseph explains, the actual damages required serves as an additional protection against large presumed damages awards that, if awarded, would merely negligent errors could chill free expression. Okay. By contrast, presumed damages can be collected when a plaintiff alleging defamation per se shows actual malice. Accordingly, actual damages are not required here. Instead, presumption of damages applies. He gonna mess around and get himself in trouble. This is too much. The conspiracy claims withstand scrutiny too. Civil conspiracy is a derivative claim that requires an actionable tort. For the reasons above, Bishop Jakes clearly established a defamation per se claim. Thus, the question becomes whether conspiracy took place to commit defamation. Ooh, wee. Let me see what it says. And while Youngblood mentions the libel proof plaintiff doctrine, which only a handful of jurisdictions recognize as a bar to recovery, Pennsylvania state courts have not yet recognized it. You know what? I'm very disappointed in that darn Tyrone Blackburn because I don't think he be reading the laws, or I need to see if he is even if he knows anything about Pennsylvania, because he may not even be licensed in it. He probably doing the pro hoc vice on this case, but I'm gonna see. I'm gonna see because I believe they were waiting on that because he wasn't even admitted in this particular district. I'm gonna look at that. A civil conspiracy requires a combination of two or more persons acting with a common purpose to do an unlawful act or to do a lawful act by unlawful means for an unlawful purpose. That's why he had his co-conspirators concoct that story. An overt act done in pursuance on the common purpose and actual legal damage. First, Youngblood and at least the YouTuber acted jointly to develop and launch the October 28th show that specifically aimed a public attack on Bishop Jakes that falsely claimed he tried to groom and sexually abuse Youngblood. Second, the YouTuber in joint action with Youngblood buttressed the false claims by stating that Bishop Jakes had fixers called to stop Larry Live from airing more episodes about Youngblood's stories, and that those efforts validated Youngblood's claims. This is the key because the YouTuber was no mere interviewer. He added to the fabric of the story above and beyond what Youngblood himself described. By adopting the statements, the YouTuber demonstrated an overt act to further the common plan, an attempt to give more truth to Youngblood's false claims. Third, the YouTuber and Youngblood acted in concert to further the common purpose by launching the second show. The November 3rd show speaks for itself. The sole purpose of it was to build on and refine the false claims from the October 28th show and ensure injury to Bishop Jakes. In particular, Youngblood's attempt to more clearly target his false claims of sexual assault by stating that plaintiff restrained himself and forcibly kissed him, as opposed to his initial claim that they embraced at the end of an hours long, wide ranging conversation about faith in life and parents. Further, the YouTuber specifically asked questions to elicit the particular information from Youngblood about the assault, and then proceeds to summarize the repeat those facts in order to guarantee the audience understands Youngblood's sexual assault accusations as such, and that Bishop Jakes is therefore responsible for Youngblood himself becoming an abuser. Finally, the primary objective of the scheme was to get money from Bishop Jakes and to harm his reputation. The YouTuber was fully aware of Youngblood's demand letter and admitted as much on an episode of his show that aired the very night the complaint in this case was filed. Ooh, as evidence of records of this case shows. Public policy does not favor letting fraudsters lie and exploit others. Youngblood claims that the court should dismiss this lawsuit on public policy alone and is not allowed. And while courts protect legitimate victims, they also acknowledge potential for false accusations of sexual abuse and the right that someone who is falsely accused has to recover for the harm thereby caused, which can be devastating. Those countervailing interests overcome any invoked by Youngblood. Defendants request for permission to join additional claims. The closing request for leave to file a cross complaint against Bishop Jakes and his son Jermaine, a non party, is procedurally improper. Youngblood cannot bring a cross claim against anyone other than those, because a cross claim is one brought against a co party. What are you doing, Tyrone Blackburn? While the federal rules allow counterclaims sometimes, Youngblood's description of events alleges no conduct by Bishop Jakes, only his son. And his son is not even part of the case. That's because Bishop Jakes has nothing to do with it, and Youngblood has no basis to say he did. And counterclaims are subject to Rule 11 and Rule 12's requirements, just like other pleadings. Moreover, Youngblood cannot counterclaim against Bishop Jakes' son, who is a non party, because Rule 13 does not authorize assertion of counterclaims against strangers to litigation. So you just can't include anybody outside who's not part of the litigation. Moreover, there is no personal jurisdiction over Jermaine Jakes because, as a Texas resident who sent a single social media message, he lacks the requisite connection to Pennsylvania. Um, Finally, to the extent some procedures exist by which Youngblood could assert his proposed claims, he cannot request the court's permission in this motion to dismiss, which cites no cognizable source of authority for the request, nor any analysis of the factors to be considered. In conclusion, the defendants, aka Duane Youngblood's anti-slap motion, should be denied. It should be denied. Um, y'all, this it's wild. Let me show y'all the exhibits. We've been on here for 44 minutes. Look at the exhibits, y'all. They are not playing. Let me see what Bishop said. Oh, Bishop, I ain't about to read all of this. Let me kind of go through this. He said, I reviewed the affidavits of Duane Youngblood and Richard Youngblood submitted in their support to motion to dismiss. The statements in these affidavits purport to describe situations where I harbored carnal desires for these men. The statements are knowingly and flagrantly false. I am repulsed by these defamatory accusations and the $6 million extortion letter I received from Duane Youngblood's attorney, Tyrone Blackburn. Okay, so that, ooh, I want to see the extortion letter. That's Exhibit 25. We're going to get to there. For years, I have counseled to ignore the constant stream of low level smears against my reputation. However, the emotional and physical toll of this coordinated campaign of lies designed to damage my reputation and legacy has become overwhelming. The pain it has caused my wife of 43 years and my 5 children, whom I have always loved, nurtured, and provided for, is simply too much to bear. Every person has a breaking point. I have reached mine. I authorized this lawsuit because I can no longer remain silent. My calling to preach the gospel began at a young age. In 1980, I founded Greater Emmanuel Temple of Faith, a small storefront church in Smithers, West Virginia. With a congregation of just 10 people, I traveled to coal mining towns throughout the state, spreading the gospel. This was a true testament of humble beginnings. In 82, I married my wife, Sarita. I embraced her 2 children from a previous relationship as my own. Tragically, 6 months into our marriage, a near fatal car accident left Sarita with debilitating injuries, confining her to a wheelchair for nearly a year. That same year, I lost my job at the Union Carbide chemical plant due to its closure, further compounding our already difficult financial situation. To feed my family, I worked nights digging ditches for gas lines with my brother. But even this arduous labor was often insufficient. It is within this context, the reality of my life in 1986, that Duane Youngblood makes his preposterous claim nearly 40 years later on the Larry Reed Live podcast, and I promised him lifelong financial support in exchange for X whenever I visited Pittsburgh. This assertion is not only ludicrous, it is a bold faced lie. To be clear, while I occasionally traveled to Pennsylvania around 1986 to preach at area churches that were part of the Greater Emmanuel International Fellowship Network, I tried to corner, grab, and kiss any teenagers. I never phoned Duane Youngblood to proposition him for X in exchange for financial support, and I never groomed, sexually abused, sexually assaulted, or engaged in predatory conduct of a sexual nature towards Duane Youngblood. I never apologized to Youngblood for any such conduct because it did not happen. During that period, I was barely keeping my own family out of poverty. I was not the Bishop T.D. Jakes of today. I was a pastor with no substantial following and no financial resources. My home was small, wood frame, structure. There were no signs of prosperity. My life was consumed with providing for my family, often amidst severe hardship. There were numerous nights when my wife and children returned to a home without water or electricity. I often share the story of how I turned the shame of utilities shut-offs into a game with my 2 oldest sons, and just 5 and 6 years old, seeing who could reach their rooms without stubbing their toe in the dark. My circumstances began to improve in 1992. I managed to scrape together enough money to travel to Tulsa, Oklahoma for the AZUSA 92 uh, evangelical conference. Initially, I was largely ignored. And yeah, I have to do that because I want to make sure I don't mess up the word. However, my fate changed on the second day when I was introduced to prominent evangelist Carlton Pearson by Sarah Jordan Powell. His support led to speaking engagement at the following year's conference, AZ USA 93. There, my sermon, Woman, Thou Art Loosed, resonated powerfully with attendees and launched me into national prominence. Before this pivotal moment, my ministry was a modest local calling. Today, I have diversified my income streams as an author, film producer, real estate developer, and more. However, during the time period referenced by Duane Youngblood, I had none of this. In my 68 years, my only involvement with the justice system has been primarily through the Texas Offenders Reentry Initiative, a faith based program that helps formerly incarcerated individuals reintegrate into society. Through touring, we have assisted over 40,000 individuals in rebuilding their lives by providing support in employment, education, housing, healthcare, spiritual guidance, and family reunification. I found myself defending my character and integrity against two convicted felons, acting at the behest of an overzealous blogger attempting to extort $6 million from me. Duane Youngblood claims to have confronted me about the alleged attempt kiss, yet I have never heard a whisper of the supposed incident until the appearance on the Larry Reed podcast. Although Duane blames his conjured up incident as an excuse for his apparent behavior, it is my understanding that he never brought any of this up as a defense in either trial that resulted him spending half of his life in prison, I nor anyone he is now maligning was brought up in either trial. Make this make sense? If this event truly occurred and was as traumatic as he claims, why hasn't it never surfaced in any of Dwayne's own M-worded cases, where such a detail would have been paramount to his defense? It is with deep sadness that I find myself responding to the egregious and defamatory claims. My willingness to address them does not diminish the need for justice. I am one of many who have been targeted by the malicious individuals. My commitment extends beyond defending myself. It includes exposing these individuals and their tactics, which often prey on those who lack the resources to defend themselves against which calculated attacks disguise the truth telling. I must add, in the consistencies in Duane Youngblood's narratives are too numerous to address comprehensively. His story changes with every telling. Initially, he claimed I tried to kiss him. In a separate interview, he stated I blocked him from leaving, which is completely out of character for me. His latest claim is that he was driving me home after a birthday party. I did notice the inconsistencies, I'm not gonna lie. I'm not gonna lie. Duane Youngblood has also implicated two other pastors, accusing one of groping him during the massage. Yet he has made no demands against that individual. He accuses me of merely trying to hug and kiss him, yet seeks to extract $6 million? Why this discrepancy? If I am as reprehensible as he portrays me, why did he join the organization where I served as a vice bishop, leave, and then subsequently rejoin? Regarding Richard Youngblood's claim, while I frequently traveled to Pittsburgh during that period, Richard and I, as two adult men, were perfectly capable of making the 4-hour trip from Charleston, West Virginia, without requiring an overnight stay at a motel. I categorically deny ever getting in bed naked and propositioning Richard. Furthermore, if he generally believed me to be a threat, why did he later approach me approximately 10 years ago in Nashville, Tennessee, at a TBN event about a job at the Potter's house? His story surfaced only after I declined to help him due to his lack of qualifications. Richard has a history of instability. He hasn't been able to maintain a job. He has multiple children with different women and a felony conviction for failure to pay child support. It's difficult to respect a man who doesn't take care of his children. Damn. In all my years, I have never initiated a lawsuit against anyone. We filed this lawsuit against individuals who supposed to be men of God but clearly are not. The catalyst for this action was simply not the nature of the accusations, but relentless attacks by the overzealous blogger. I have faced many attacks in my life, but none like this. Even so, I feel compelled to stand up against these bullies. This is carefully orchestrated attempt to destroy me. An overzealous blogger publicly solicited individuals to make accusations against me, not for the victims to come forward, but for anyone willing to fabricate stories. He explicitly stated his strategy in one of his podcasts before his interview with Duane. The claim doesn't have to be true, it just needs to be filed. Once it's filed, I could talk about it on my show. Richard and Duane Youngblood responded to this call. They are working in concert, relentlessly targeting me and my family with vicious, unfolded attacks. I spent the past year enduring their vicious attacks, lies, rumors of my wife leaving, rumors of my church abandoning me, and so much more. All of this was happening while I found myself helping my wife recover from knee replacement surgery and while helping my brother navigate kidney failure. This unwanted stress brought me to a place of having a health crisis on stage in front of my entire congregation. As a guy who'd had no previous health challenges, this near death experience was a turning point for me. Enough is enough. I suspect a larger network is involved in this scheme, all anticipating a share of this attempt money grab. Dwayne's ambition and confidence in extorting $6 million from me are evident in his preemptive actions, establishing a website, commissioning artwork, hiring a publicist, and announcing the launch date for not one but two books, a tell-all about me and another entitled How to Get Rich. All of this was in motion before I even received the $6 million extortion letter from Blackburn. Blackburn has stated that he's not getting paid by Dwayne, and if this is true, the question must be asked, who is funding Blackburn's efforts? The only logical explanation is that he fully expected me to succumb to the pressures of his false accusations and pay him $6 million to remain silent. Finally, Dwayne and the overzealous blogger had already publicized this fabricated story. Why would I pay them not to tell something that they already broadcast to the world? This tactic aligns with Tyrone Blackburn's established pattern of behavior. This entire smear campaign began shortly after the public announcement of the commitment from Wells Fargo of up to $1 billion for commitment redevelopment. This initiative is designed to provide quality, affordable, and workforce housing, broadband access for children lacking adequate internet services, fresh grocery options and food desserts, job creation and training, and comprehensive support services for underserved and undercapitalized communities. This partnership was never intended for my personal gain. It is a testament to my commitment to giving back to the community that has supported me for decades. In summary, I have no ulterior motive. I desire peace, accountability, and an end to this harassment. I pray for an expeditious resolution to this matter, one that respects the integrity of the federal court process and allows me to continue the work that is most dear to my heart, investing in the lives of the most in need. My deepest concern is that others will be victimized by their vicious collaborative tactics. Unless the law intervenes, this pattern of abuse will continue. Mm, that's deep. Let me see. And I think this is the affidavit for his son. If it's long, I'm not gonna too much read it. Let me see. He's just talking about the smear campaign. He said on November 3rd, he was looking at his social media feed and noticed an advertisement promoted by Larry Reed Live show podcast for an interview with Duane Youngblood. The abused becomes the abuser. He states that he was immediately concerned that Duane Youngblood might be putting himself in harm's way by involving himself as Larry Reed. And he's saying, based off of his personal experience, he knows that Larry Reed's podcasts create controversy that can be very destructive to people's lives. And he also stated that his father has been attacked by Larry Reed for a period of years. On the 3rd, he sent a message to Dwayne. And he said it was a cautionary warning to someone I know, Duane, to avoid Larry because my experience is that Larry Reed distorts facts and is not truthful. He also stated that he has not talked to Duane in over 30 years. He hasn't seen or talked to him in over 30 years. He um, he said, I know Duane from growing up in West Virginia. Their families were part of the same church and community, and Duane's brother, Richard Youngblood, was his youth pastor. Um, he said when he saw the message, he did not see the podcast, so he didn't know what was stated or that his father was the focus of the discussion, and so there was no reason of him to say anything that he intended to be meant to be threatening. So that makes sense. So pretty much he didn't see the podcast, so he didn't know. But what he said was not intended or meant to be threatening in any way. And he said Dwayne responded to my message practically, immediately stating that he received the message and it was noted. Yeah, this is interesting. But let's go. What did they say that darn extortion letter was? Oh, this is, I think that was the church. Oh man, hold up. 23, 24. We're gonna find it. I'm trying to find this extortion letter, y'all. All right. So that is an article about Diddy. Exhibit 24. That's a lot of exhibits, child. What? YouTube. Oh, this is talking about the YouTube stuff. Oh man. All right, here we go. Found it. Here is the what they call extortion letter. My firm has been retained by Duane Youngblood regarding harm visited upon him by Bishop Thomas Dexter Jakes. The nature of Mr. Youngblood's concerns unwanted sexual assault and harassment. This letter is intentionally void of the graphic details. The purpose of this letter is to encourage the parties to resolve this matter quickly and privately. For settlement purposes only, the opening settlement demand is $6 million. This demand is negotiable. Mr. Youngblood first learned of and was introduced to the respondent as a younger teenager. Mr. Youngblood was raised in a church, and his family often visited Bishop Wade Jones' church throughout Mr. Youngblood's teenage years. Respondent often visited Bishop Jones' church. What? Why did? Okay, this is weird. During one of those visits, respondent, you know what? This is getting me because, like, why do you have an apostrophe after the S? But whatever. Respondent began assaulting and harassing Youngblood upon information and belief. He was between the ages of 17 and 19. Okay. Okay. The conclusion, $6 million. They saying it's negotiable. They saying that they need to pay him to compensate him for his physical trauma that he endured as a teenage boy. They gave him until November 23rd to respond, and they said, we will review your silence as a rejection of this offer and proceed to file suit without delay. Mm, I'm just looking at Blackburn stuff because I'm just like, eh. This reminds you of like the Jane Doe situation. But this is interesting. Now, it's a lot of exhibits I'm not going through because I'm pretty sure that there are pictures and stuff, but I did want to show you guys the extortion letter as well as the affidavit of TD Jakes and his son. And then my next video, I'm going to cover Dwayne's response because he going back, him and his brother, like, look, y'all some liars. Y'all are some liars. But this was TD Jakes, Bishop TD Jakes' response um to Duane Youngblood's motion to dismiss this whole action. Pursuant to the anti-slap laws in Pennsylvania that don't even apply to this case because it's a federal case. And if that wasn't even the case, parts of that the slap statutes are not even in effect yet. So once again, I don't know what Tyrone Blackburn be doing. I've been questioning him since the Little Rod case, and I'm still questioning him. But y'all let me know what y'all think in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed, and I'm out. Bye.